Hi, my name is Reed Bloodworth. I'm a business litigation and estate and trust litigation attorney in Orlando, Florida. Today, I would like to talk about estate and trust litigation in a scenario that I've experienced. The scenario is this. A father and son came together and formed a construction company. They ran this construction company together as father and son, as partners, for 25 years. In the last 2 years of the father's life, he was diagnosed with Alzheimer's. Also, a little time prior to that, the son started a separate business, a consulting business, a single-member LLC. During the time period after being diagnosed with Alzheimer's, prior to his death, the father began accusing the son of stealing from the company. He accused him of stealing money, of stealing equipment, of starting a company unbeknownst to him, competing against the partnership. The father wanted to dissolve the partnership and eventually even wanted to just keep it all for himself. Please recall, this is all taking place while this gentleman had Alzheimer's. Sadly, the father passes away. At the time of his passing, the father had not instituted any litigation against the son pertaining to his allegations of theft and fraud and things of that nature. The mother, the wife of the husband and mother of the son in this scenario, was named personal representative in the decedent's will. Prior to his death, his will was not changed. The mother and son were the beneficiaries of the will, nor did the will address how the partnership was to be handled after his death. The mother's question in the scenario was, can I bring a lawsuit based upon my husband's allegations against my son, and should I? Well, the answer to the first question is yes. As a personal representative, the wife had the ability to bring a lawsuit against the son if, in her role as personal representative, she believed there were assets there that could be brought into the estate. However, should she do that is a different situation. Her husband and the father of the son in that scenario had Alzheimer's. Ultimately attributed to his death. So, should the wife institute some type of lawsuit based upon the statements made of someone with severe Alzheimer's? I would suggest probably not, especially considering the will. As I said, both the son and the wife were beneficiaries under the will. Instituting a lawsuit against one of the beneficiaries to bring assets into the will's estate only to be redistributed to the son and the wife doesn't make a lot of sense. It could potentially be a breach of fiduciary duty by the wife. The other question is, well, at that juncture, what happens to the assets of the partnership? Well, the son and the wife could discuss that and make that decision on their own, or they could, his share of the assets of the partnership could pass in the probate estate. But again, there's different scenarios there that could be worked out. But the bottom line here is, should the wife instituted a lawsuit against her son based upon statements made by her husband who had Alzheimer's? Probably not in that scenario. So again, my name is Reed Bloodworth, attorney in Orlando, Florida. Give me a call. Let's talk about what happened to you.